Hi, it's Wendy Hernandez with Command the Courtroom. In today's video, I want to talk with you about writing. And the reason I want to talk with you about writing is this. A couple of weeks ago, I consulted with a potential client, and this potential client had gotten a document preparer to help him in preparing a petition to modify custody and parenting time of his children. What ended up happening, though, was when the judge took a look at the client's petition to modify that the document preparer had prepared, the judge found that that petition did not set forth a legal reason for custody to be modified. And as a result, the judge just dismissed the case. The judge didn't even give the potential client a hearing. And I will tell you that doesn't happen a lot, but more and more judges are doing it because they're so overwhelmed with cases. And if they don't find that the person establishes the bare necessity of what they need to in their motion, in their pleading, the judge may dismiss the case. So this is my tip that I gained, and I want to share with you from that experience that my poor potential client had, and that is this. When you are preparing or writing a petition to modify, or any kind of petition for that matter, the facts of your case are very, very important, and you have to lay those facts out there. The judge has to understand why your case is different from all the other cases he or she is handling. The judge has to understand if you're seeking a change in custody, why a change might be warranted. So for example, in Arizona, in order to modify custody or parenting time, you have to show the judge that there's been a substantial and continuing change in circumstances. But it's not enough to just say in the motion that you're preparing that there's been a substantial and continuing change in circumstances. You have to set forth the reasons why there's been a substantial and continuing change in circumstances. So I'm guessing whatever state that you're in, whatever country that you're in, if you want to change something with the court, you're going to have to tell the court why it should be changed. So this is where the facts become very important. You don't just state the legal standard or the legal basis for changing and saying you want to change because there's been a change in your situation. You say why. You say maybe it's been 5 years since the original custody and parenting plan was entered. So time has passed, but keep in mind, time alone is probably not going to do it. You may add on, for example, say your child is doing differently in school than he or she was before, or recently there's been a decline in grades, or that the school is closing down. Maybe you've gotten remarried or are in a new relationship. Maybe the child has new siblings or step-siblings. There are a lot of reasons why a case may be changed, and you have to set those forth. You have to tell the judge exactly why you're requesting the change. Details matter. Facts matter. And if you don't lay it out there, you could end up in the same boat as the potential client that I met with, and your case could just get dismissed without you having a chance to talk to the judge about it and plead your case. So when you're preparing your paperwork, look at the facts of your case, get into them, describe them for the court, give the judge the flavor for your situation, and give the judge the reasons why he should give you what you're asking for. So if you haven't already, head to commandthecourtroom.com. There you're going to find the free best interest checklist. You'll find some interviews that you can have access to and all kinds of other goodies, as well as the rest of my videos. If you haven't already, subscribe to the YouTube channel, like us on Facebook. Keep on trucking, and until next week, remember to command the courtroom.